I'm Atmija Tripathi, law student from Symbiosis Law School, Pune, India. I would be dealing with the second part of our paper, which is bifurcated into three segments. Firstly, legal status of marriage under Hindu personal laws and its consequences. Secondly, I would enumerate the implication of non-recognition of third gender right to marry. And lastly, few suggestive remarks as to what can be done in the Indian scenario. Moving ahead with the first part of the discussion, which is legal status of marriage and its consequences. Codification of Hindu customary laws dates back to mid-20th century, wherein a number of legislations were brought into effect to encompass the traditional customary Hindu laws of marriage, inheritance and succession. The most fundamental piece of legislation being the Hindu Marriage Act of 1955. Under Section 5, it lays down essentials of a valid marriage. Section 5, subclause 3 states legal age of the bride and bridegroom who are parties to a valid marriage under Hindu laws. However, a major lacuna which is faced by the interpreting authorities and individuals is that this legislation, this piece of enactment lacks definition of key terms like bride and bridegroom. This lacuna was highlighted by the Madras High Court in the case of Reema Agarwal versus Anupam and others, and I quote from the judgment: even though the legal definition of marriage as has been interpreted, brought down through judicial interpretation, is a legal union of a man and woman who is husband and wife, yet again these terms have not been defined under any law. Now, in the absence of these definitions, when a statute is ambiguous, throughout the world harmonic interpretation is used in case of ambiguity. It is incumbent on courts to take into consideration the legislative background, the intention of the legislators, the objective behind enactment of a specific legislation. In this context, it is necessary to go back to the legislative intent behind enactment of Hindu Marriage Act of 1955. This piece of legislation was brought into effect to codify and bring in uniformity amidst the different customary practices and tradition prevalent during that period of time with regards marriage and rights of inheritance and succession. Keeping this in mind, we must take into consideration an important factor, which is that Hindu customary laws were known to be inclusive of gender and sexual preferences that fall within a wide range of spectrum, not merely bound by the binary gender classification of male and female. In such a scenario, judiciary must give a broader interpretation to the term of marriage, which must recognize right of marriage of third gender people. This is the place where the performative theory as laid down by Judith Butler comes to picture. By application of this theory, third gender marriage can be given valid recognition by considering the role performed by each individual in the marriage. Moving ahead with the consequences of marriage under Hindu personal laws. Marriage brings with it a bundle of rights like inheritance, succession and right to property. And under Hindu personal laws, these have been codified under Hindu Succession and Inheritance Act of 1955. This is based on the co-partitionary model, which also categorizes rights and recognizes rights of two sets of individuals, that is Hindu male and Hindu female. This is necessary, and this fact necessitates to recognize the right of marriage of third gender people. Moving ahead with the third part, which is implication of non-recognition of the rights. Now, in the Indian society, third gender people who are in the major part of the country, referred to as hijras, are ostracized from the societal norms and society. So they move into their own homes, which is a close-knit community of the Hijra Gharana. There in the Hijra Gharana, they live in a close kinship which flows through affiliations and familial ties between the gurus and chelas, which is basically colloquial terms for the teacher and the disciple relationship. However, in those Hijra Gharanas also they have to face atrocities, and they face repeated threats of ostracism from the close-knit community. Still, they prefer to stay in the Hijra Gharanas because of the limited protection, economic and emotional protection that is guaranteed therein. Moving ahead with the last part of the discussion, which is what can be done in the Indian society so as to protect the rights of marriage and inheritance under Hindu laws, especially of the third gender people. The most important fact being broader interpretation by the judiciary, which is already enumerated by me. Second important fact is that there is a need for bringing amendments to the present legislation, especially that of Hindu Marriage Act and the Hindu Succession and Inheritance Act. This will protect the rights of the third gender people and will prevent and restrict any sort of indiscriminate discrimination which is meted out to them, and it will protect the right of equality and right of life and personal liberty, which is a right, fundamental right recognized by the Indian Constitution. Further, India's obligations under the Yogya Karta principle and various UN Special Rapporteur report, especially that of Van Muner dating back to 2010, necessitate recognition of these rights by applying doctrine of incorporation, which is also a constitutional mandate in India. These rights, especially the Yogya Karta principles, have been recognized by the Indian Supreme Court in the judgment of National Legal Services Authority versus Union of India. So, from all this discussion, what ensues is that in the backdrop of the fundamental rights and protection of these fundamental aspects of third gender people, it is necessary that Indian legislators must bring changes to the existing piece of legislation so as to recognize their rights, so as to give them a platform where they can enjoy the right of life and personal liberty, right of marriage and inheritance and succession, equally as that of the other people belonging to binary gender classification. Thank you.